After the Constitution of India coming into effect, Jawaharlal Nehru wrote this to all of the chief ministers, and I quote, "It is the right of the judiciary to interpret the Constitution and to apply it, and none of us can or should challenge that. But if the Constitution itself comes in our way, then surely it is time to change that Constitution to that extent. It is impossible to hang up urgent social changes because the Constitution comes in the way, according to the interpretation of the courts." What were these social changes that Nehru talked about that were so profound that he had to amend the fundamental rights of the Constitution just a year after the Constitution was enacted? And all of this just to allow the Parliament to pass laws of the sorts that the High Courts and the Supreme Court would outrightly declare them unconstitutional. And anticipating this action, the amendment prohibited the Supreme Court and the High Courts from declaring these laws unconstitutional. Also, was the Nehru government justified for passing these laws by a temporary parliament instead of waiting for Lok Sabha and Rajya Sabha elections? This is Hamlet of Law, an Indian legal podcast where we discuss judgments of Indian courts, the laws, policies, and the politics behind these laws and policies, and everything official to judicial. Stay tuned to find out. This is your host Naren Rudra, and this is the inaugural episode of the podcast. In this episode, we'll explore the very controversial First Amendment to the Constitution and how this amendment diluted the property rights of the citizens by validating Zamindari abolition laws with a questionable procedure and without a proper mandate. This too, just 15 months after the Constitution was ratified. We'll discuss why the Nehru government amended the constitution this soon after it was enacted, and also how the Supreme Court dealt with the validity of this amendment by forming the first ever constitutional bench in the matter of Shankari Prasad versus Union of India. And, unlike traditional sources on the subject, we'll be equally focusing on the arguments made in the cases as well, because this case and all cases of constitutional significance have very wide repercussions, and the lawyers involved in these cases are the best and brightest in the country, so their arguments, clarity of thought, their depth in the subject, and the way they articulate everything is as good as they can get. So I'll be focusing on arguments as well. Now, before going ahead, keep in mind that the First Amendment broadly made 5 changes. 1. It allowed the state to restrict free speech. 2. It allowed the state to earmark seats in government jobs and colleges for socially and educationally backward classes. 3. It restricted trade and business by allowing very invasive government interference on the pretext of regulations. 4. It validated Zamindari abolition laws. And lastly, 5. It created Schedule 9 and prohibited the courts from declaring laws unconstitutional if inserted in Schedule 9. We'll just discuss the laws abolishing Zamindari system, Schedule 9, and how this amendment was passed in this episode. So, let's get down to it. India fought very hard for its independence, and it was a true moment of joy when Britain's parliament passed the Indian Independence Act 1947 and ordering dominions of India and Pakistan to be demarcated by midnight of August 14th and 15th of 1947, and then transfer all of the powers to India and Pakistan. For the first time ever, Indians actually had the power to elect their leaders, but there was no framework set out yet to elect leaders. So for the time being, the British government virtually transferred the powers to the interim government, which was elected by a body which was formed to draft the constitution, the Constituent Assembly. And this interim government, more or less unchanged, went on to perform all the duties of the Union Cabinet until Lok Sabha and Rajya Sabha elections were held. The administration aspect was taken over by the interim government. On the other hand, the parliamentary functions were performed by something called the temporary parliament, or as it's also called, the provisional parliament. This provisional parliament was called the Constituent Assembly for close to 3 years because it was given the task of drafting the constitution, and this body was elected indirectly, and a significant number of them were just delegates from the princely states. Members to these bodies were elected by the state legislatures, which was in turn elected under the Government of India Act 1935, and under this act, only members of certain education qualifications and people with certain amount of property were eligible. So this Constituent Assembly was not really representative, but it was very much qualified to draft the constitution. And the Congress back then ensured that this Constituent Assembly was as diverse as it could get. So, after fully framing the Constitution, it was ratified by the Constituent Assembly, and then this assembly became the Provisional Parliament until Lok Sabha and Rajya Sabha elections were held. So, this is the reason why this body is called Temporary or Provisional Parliament. So, the same body was called Constituent Assembly until January 26, 1950, and Provisional Parliament from January 26, 1950 till the Lok Sabha and Rajya Sabha were summoned. Interestingly, the elections were held a little late because the country hadn't yet settled on a lot of things like voting age, communal electorates, presidential or prime ministerial form of government, and finally settled on these aspects on the basis of constitutional principles, and then passed the Representation of People Act, and the elections were held according to this law. Meanwhile, from independence till 1952, the Provisional Parliament was acting as a parliament at the centre, and the newly independent state governments were formed by the Congress leaders, who were again mostly elected under the Government of India Act 1935 before independence. Now, these newly independent states had a lot of social problems to deal with, and one of the biggest was unequal distribution of lands, where a few people held lands that spread across hundreds and even thousands of villages. And this system and this sort of accumulation of lands has a lot of history to it. And to understand why the government diluted our property rights and why it enacted the laws that take away the lands from the so-called zamindars and redistributed all of these lands to the farmers, we have to understand the deeper history behind it. So, by the time India achieved independence, and also for the most part of the modern history, small farmers never actually owned their lands. They used to lease them out for a rather hefty price from the zamindars. Now, zamindars or jagirdars were these huge landholders who got these lands as grants by the government itself or the kings and princely estates. And the less discussed side about zamindars and all of this distribution of land is they didn't get this land by just loitering around. The state used to allot them these lands in return for some service to the state, that too mostly military service through their private army. The other way where zamindars got all of these lands was the kings or the British used to auction off huge tracts of lands again to a person who promises to pay the highest periodical tax. And in case they fail to pay the tax or fall short of it, the government would simply take away the land from them. Now, zamindars also used to develop the land under their control, mostly by maintaining proper roads, ensuring free water flow, and developing infrastructure in general, because a proper ecosystem in their land would ensure easy produce of crop, meaning the farmers could earn more money, and with this money, the farmers could easily pay the land tax to the zamindars. Now, we're digressing a little bit, but it's interesting to know that this land tax is what we call land revenue. And land revenue was a major chunk of earnings for both the British and the kings. So that's why they used to be very stringent and harsh while collecting land tax. And the person who's in charge of collecting land tax is called a collector, because he used to collect land tax. And this collector was virtually the most powerful person in a defined area, and we still retain the name collector to refer to the head of the district collector. Interestingly, we call land laws revenue laws because the government used to frame laws to maintain records of ownership and possession of lands only to collect revenue. So, lands dealing with ownership and possession in general are called revenue laws. Now, back to the topic. This zamindari system was very much thriving when we got independence, and for the reference, in the later part of the 1940s, 72% of India's population was engaged in farming, and out of that, only a small fraction, less than 1%, was actually owning the land they tell. And almost everyone were tenants of some or the other zamindar. For example, in Oudh, which was a princely state comprising of current day central Uttar Pradesh, 60% of land was under zamindar's control, and Uttar Pradesh was the biggest state by population even back then, with 17% of India's population living there. And if we come further down to the south, in Madras Presidency, 33% of total land was owned by zamindars. So with these numbers, you can understand the magnitude of inequality with respect to land holdings in India. This system wasn't fair to the farmers because most of India wasn't educated, and the only way to eke out a living was farming. So they needed land to survive, and for this land, they had to pay taxes to the zamindars or the government directly. And after paying these taxes, they would be left with just enough resources to have a basic living. And on top of that, there would be no security over their livelihood, because if they fall short of paying the tax or if they just refuse to, they used to simply get evicted from the lands. And more often than not, they used to get evicted from the lands because they couldn't afford to pay this land tax regularly, because either it was way too high, or they couldn't produce any crop for that season, or for a host of other reasons. There were actually cases where zamindars supported the British during the independence movement because they were thriving under their system, and they knew that with the socialist agendas of the new freedom fighters, they would not let this zamindari system continue for long. Now, with this ruthless system in place, the farmers just wanted a way out and have a safe, secure, and content livelihood, and the Congress and communist leaders promised just that. After independence, our constitution framers envisioned India as a socialist welfare state with little to no inequality. And this has also been the ideology of Indian National Congress, especially on the property front. And this can be seen from Congress endorsing the abolition of Zamindari system strongly from way back in the 1930s. Finally, after independence, the Congress government came to power and they started discussing seriously to get away with this inequality. And the straightforward option was to take away all the lands from the zamindars except for a few hectares and redistribute this collected land to the farmers themselves. After independence, the Congress party formed government everywhere. It got majority of votes in almost all of the state legislatures in elections held before independence under the 1935 Act, and also in the 1952 general elections, it comfortably passed the majority mark in parliament. And guided by these socialist welfare state principles, the Indian National Congress carried out huge agrarian reforms. Now, India's governance has a few elements of federalism. So, states are in a way a sovereign in a sovereign state, and on a few issues, states have no higher authority over them. Whatever the state says, that is it, that is final. So, with this federal structure, the states have exclusive control over a few subjects such as public order, lands, prisons, public health, and no authority, not even the union government, can interfere with these powers. This distribution of powers between union and the states is listed out in Schedule 7 of the Constitution, and this schedule has three heads. The first and second are union list and state list, which have subjects that are exclusively under the union's control and the state's control. Then the third one is concurrent list, where both union and states can frame laws, but once the union frames any law on any subject in the list, the laws that were framed by the states stand repealed to that extent, and the laws passed by the union will take the ground. Now, in very extreme cases, union government can make laws that are in the state list too, but as I said, they are very extreme and they hardly ever happen. Now, the subject of land is in the state list, so states have the exclusive right to frame laws and policies on land, and since the state governments were again formed by the Congress party, the states carried out these huge land reform laws all across the country. But the most affected parts were the northern states, because the Zamindari system was a Mughal vestige, and Mughals' influence in southern India is very little and it's very pervasive in northern India. So, all of these states passed these land reform laws acquiring almost all of the lands of the zamindars. For example, if a zamindar owned 120 acres, the state limited the ownership at 40 acres and would go on to acquire the rest of the 80 acres, and that too without any equitable or reasonable compensation for acquiring such excess land. Then the state enabled itself to redistribute all of these lands to the farmers, that too mostly in such a manner that where the farmer who used to till the land as a tenant was given the ownership of that very land. And after successfully passing these laws, one of their long standing agendas were fulfilled. They have been promising the land reform laws from way back in the 1930s. Now, as soon as these laws were passed, Zamindar started approaching the local politicians and other people in power and tried to convince them to roll back these new land reform laws. But the highest rung of Congress party was very adamant and didn't even budge an inch and wanted to go ahead with this abolition and the system at any cost. With these talks still underway, the Zamindars moved to the high courts through writs under Article 226 and attacked the validity of the Zamindari abolition laws. Since it was just 1951, Article 31 and Article 19(1)(f), both of which protected property rights and any undue interference of state on the property, were very much alive because they were repealed all the way in 1978 through the 44th Amendment. So the Zamindars in the High Court argued that these laws were violative of their right to property because the government was depriving them of their land without any fair compensation. And this word compensation has a lot of history in Indian jurisprudence, but we'll discuss that in another episode. Now, the Zamindars here challenge the laws as violative of Article 31, of which Clause 1 reads, and I quote, no person shall be deprived of his property save by authority of law, unquote. And Clause 2 of the same article mandates that any acquisition by state shall be for the public purpose and must compensate the owner of the property if the state were to acquire it. And also these Zamindars challenge them on the ground that it violates Article 19(1)(f), which protects an individual's right to acquire, hold, and dispose of his property. Since these laws were challenged in multiple high courts and decision of one high court is not binding on other high courts, the orders and judgments were not uniform across India. The Patna High Court, in the very famous case of Kameshwar Singh versus State of Bihar, declared Bihar's land reform laws unconstitutional, while the Allahabad High Court was yet to decide on the constitutionality but passed a string of injunctions which restrained the state from acquiring any property under the new land reforms, and a few other high courts upheld the constitutionality. Here, interestingly, the Patna High Court didn't declare the state's land reform laws unconstitutional because the government didn't have the eminent domain, that is, the power to acquire land of any citizen, and that such power was violative of Article 31 and 19(1)(f). The Patna High Court declared them unconstitutional because Bihar's laws were discriminating while compensating the landholders. For example, here the compensation for lands acquired from an individual with huge land holdings was significantly lower than that of landlords with small land holdings. And this unequal treatment was clearly violative of Article 14, and for this reason, it was declared unconstitutional. And also, interestingly, when this case was appealed to the Supreme Court, it was none other than B.R. Ambedkar who argued in the Supreme Court against the Zamindars. Unsurprisingly, in all these cases where the states lost, they appealed to the Supreme Court, and where the petitioners lost, even they appealed to the Supreme Court. And while all these cases were pending and all these appeals were pending, the Union government was very flustered with these judgments and court orders because they came in the way of these long overdue reforms and also the past promises of the Congress government. So they wanted to override all these judgments through an amendment to the Constitution, which will effectively provide for land acquisition and among host of other things. Now, various high courts also declared a few other laws void for violating fundamental rights and therefore barred the executive, that is the police and other enforcing officers, from a lot of their actions. For example, the Madras High Court in Champakan Dorairajan case struck down caste reservations for being violative of Article 14, the equality clause in the Constitution. And in Romesh Thapar and Brijbhushan cases, the Supreme Court struck down orders of a state branch which banned circulation or publication of a magazine that was critical of Nehru government and nullified government actions that restricted freedom of speech for being violative of Article 19(1)(a). With all these court orders in place, the state governments were unable to carry out these land reforms. The Nehru government didn't want any obstacles to these reforms, and it was also very resolute on undoing the court orders, and amendment to the constitution looked like the only option. The Congress government wanted to amend the fundamental rights of the very constitution, which it played a huge role in framing. The Congress government here was heavily opposed while trying to amend the constitution, even by the President of India. One of the criticisms of this amendment was that the Nehru government just passed the amendment when elections were right around the corner, and since the land reforms took a big pause, and as a result of this, the people got dissatisfied with the Congress, and to win the people back, the Nehru government passed this amendment in haste because the Communist Party, which was the only strong contender to Congress back then, promised to solve all of these issues if voted to power, and the Communist Party and their ideas actually started gaining traction by this time. This is part 1 of the episode. To find part 2, find the link in the description. For regular updates, follow us on Instagram and Twitter at Hamlet of Law, and the PDF version of this episode will be found on thelawreporter.m.